Today on Law Weekly, we look at the legal defense of a no-case submission. My guest is Mr. Leonard Anyogo, a legal practitioner, notary public, and an author. We also have details from the meeting of the leadership of the Nigerian Bar Association and the Conference Planning Committee of the fast-approaching 2017 Annual General Conference of the NBA, plus our review of the top trending stories from the courts. Hello and welcome to the program. I am Shola Shuyeli. There's been so much reaction trailing some of the decisions from the courts in recent times, especially the acquittal and discharge of the Senate President and a judge of the Federal High Court, Justice Adeniyi Ademola. They both got off after making a no-case submission. But some people wonder, how is it possible for them to claim that no case has been made against them? So I began by asking my guest what elements constitute a no-case submission.
Well, the issue of a no-case submission is a constitutional right of an accused person who is standing trial. You know that the Constitution, by virtue of Section 36 of 5, 1999 Constitution, has amended, presume an accused person innocent until the contrary is proved. So, what the position, the most accused person opted for a no-case submission. That is, what it means is that I don't have any answer to give to what you are saying. What it means, if you want to be a little bit harsh, that's what you have said, it doesn't concern me, I don't have any business answering you. And most times the prosecution is put on the spot of complying strictly with the requirement of the law, especially Section 302 and 303 of the Administration of Criminal Justice Act 2015. You know, spells out those elements that the prosecution must prove. One, that especially Section 303 talks about the prosecution has to set out exactly the case, his own case. For instance, one, that the accused person is linked to the crime, the offense that have been charged is sufficiently proven. You know, those elements of offense must be proven. Then the most important is that you must link that offense to the accused person. If you fail to do so, the accused person says, look, what you have said doesn't concern me, I'm not linked to the crime that is I'm being charged. And so the court will look at it. If the court finds the accused person so perfect to say that, look, you don't have any case to answer based on what the prosecution has done. And in most cases too, sometimes during cross-examination of the prosecution witnesses, those witnesses have been so discredited that no reasonable court will convict on such discredited witness. So the accused person walk. So the onus is on the prosecution, because constitutionally speaking, the accused person is deemed innocent. So you must set out your case verbatim as required by the law.
Let's look at the case against the Senate President. Some people think that it could have been proved by documentary evidence, and to say that because the witness testimony has been discredited, did not, link the man to the offense. But if it could have been proved by documentary evidence, do you think that the tribunal really did justice in that instance? In
the Senate President case, with respect, here was a witness that they tendered. I think I follow up that matter to an extent. And the witness said the document I would have tendered was destroyed. The evidence before the court is what the court rely on. If you say the document linking the Senate President to the offense charge is destroyed, the court can't manufacture it. It's based on what is before the court. So in this case, it was very fatal to the prosecution that the document you want that links the accused person is not available.
The prosecution has indicated its readiness to go on appeal, and they've actually filed an appeal against the Senate President. But do you think that they're wasting their time?
As a practitioner, I wouldn't want to prejudge the outcome of the appeal. But from the hindsight of the law, I think they will still have to feel, because on appeal, the appeal court will look at the processes, the documents. It's reviewing the judgment. You are not bringing in additional documents. So what is on the table is what the accused in the appeal court will look at. And if you ask me, it's most likely they will fail, because it's at the trial court that the accused person, the prosecution really has a chance to prove his case.
And you say it's the same with the case against Justice Ademola?
Well, in the case of Justice Ademola, it's quite an unfortunate one. Right from the processes leading to the trial, there were some persons that were against, some were for. His house was raided. And then with respect, the term media trial, in terms of fighting this corruption, has been blown to an extent that, look, there was a predetermined outcome already that this judge must be guilty. So much money was seen. I know. Let me quickly say something. When prosecution present this case, the aim is not to convict. I want to be on record. The aim is not to convict, but to seek justice. But with respect, there seems to be that, look, their aim is to always convict. Because justice is a tripartite way. It's for the accused person, it's for the victim, and for the society. So these three elements must be taken into cognizance. Because one, once you are accused of an offense, you have all the liberty to defend yourself. So the public should not be in a haste to like condemn an individual who has been accused of an offense. So if we do so, and we expect the court to follow suit without looking at the evidence presented, the society will be an anarchy, because we're a constitutional democracy. We're a country of laws. So these laws have made provision to safeguard. In fact, that is why we have this adage that normally it's better for 99 thieves, in quote, to let go than an innocent man to be sentenced, to prison or to death, as the case may be. So the law, as it is, actually favors an accused person. So that's what the Constitution says, that he's deemed innocent. So you are proving otherwise. So the prosecution must work hard, must follow the tenets of the law.